let's talk about what the statute says. When we look at one provision in the statute, it talks about a process that the chief actuary starts every single year. By the way, that's supposed to start this year. So every single year, starting this year, the chief actuary makes a prediction. Now, this is a prediction, we can't know for sure, but what he does is he has this complicated formula, and he goes through and he determines what he thinks healthcare costs are going to be under Medicare in the future. And if the healthcare costs for Medicare get to a certain level, and for our purposes, it's roughly inflation plus 1%, actually changes depending on the year, which of course is nice and complicated for everyone, but let's just say roughly inflation plus 1%. If he predicts or guesses that that is what Medicare costs are going to be for the given year, that triggers IPAB's duties. In the next year, so this will be 2014, that'll be the first year that IPAB can possibly operate, IPAB then has to find ways to cut Medicare costs to get to that target rate. So what they do is they make what the law calls proposals or recommendations to get to that rate. So what do these proposals or recommendations look like? Well, your guess is as good as mine. But if we look at the statute, we see what the guidance is. And it mentions cutting reimbursement rates for services and goods. So a service that a doctor might provide, a medical good that you might get, something like that, right? Talks about cutting reimbursement rates. But that's not the only thing that IPAB can do, can include in its proposal, rather. Because when we look at what guides IPAB in making its decisions of where to cut, we see that the statute, ObamaCare, says that IPAB can basically do anything as long as it is related to Medicare. What does that mean? I don't know. It's not defined in those 2,000 some pages that, by the way, I had to read myself. Talk about a bad homework assignment. Man, a lot of paper cuts. I hope ObamaCare will cover that for me. But anyway, we don't know. Related to Medicare. Still doesn't sound too awful, though. It's a very broad scope, but remember, these are proposals or recommendations, right? And sometimes it's good for Congress to get proposals or recommendations when they make their decisions. Congress, ever since Medicare came to be, Congress has historically had the role to review Medicare costs and make determinations, and if a board can help them by making proposals or recommendations, so be it, right? In fact, we know that there's already some groups out there that do that, so it doesn't sound so bad. Except for that the Independent Payment Advisory Board is really a bit of a misnomer. And that's because there's really nothing advisory about it. These proposals or recommendations become law automatically every single year that IPAB makes them. I kid you not. The statute says that on August 15th of every single year that IPAB makes a recommendation, the Secretary of Health and Human Services must, not may, but must implement those into law. Every single year. So they automatically become law. And what is worse than 15 unelected, unaccountable bureaucrats making law? That would be one unelected, unaccountable bureaucrat, because if President Obama does not appoint anyone to the Independent Payment Advisory Board, then the law says, well, Secretary Sebelius gets to do this completely on her own. So in other words, Secretary Sebelius could be making laws on her own. Kind of scary. And this can all start as early as next year. Now, that's scary, but let's think, all right, well, what if Congress, Congress is the one that makes the law in the first place. Congress is the one that's traditionally been involved in Medicare, setting costs. So what if Congress wants to step in and say, IPAB, what you're doing is kind of ridiculous. That's not something that we want. That's not where we want Medicare to go. Let's step in and, and put forth our own proposal. Well, what can Congress do? Congress has to basically beat IPAB to the punch, because IPAB recommendations automatically become law on August 15th. So if Congress doesn't like what IPAB is recommending and wants to put something else in place, it has to beat IPAB. You have to get both houses to pass it, and the president has to sign it in this short little window. Because IPAB introduces its recommendations very, very early every single year. So you've basically got a few months for Congress to put together what they think is a better proposal, get both houses to pass it, and get the president to sign it. Now, how many of you think that that's going to happen? Probably not, right? What is the reason? One of the reasons that Congress gave for creating IPAB in the first place is that, well, you know, politics are politics, and it's really too hard for us to do anything with Medicare, so we've got to get the politics out of the way and give it to some independent board, right? Well, if that is truly the case, then I don't think in a couple months' time you're going to get two houses and the president to agree on anything related to Medicare. And even if you can get Congress to supersede IPAB's proposal, they can't really do anything all that different. They can't make different cuts in different amounts. They have to keep the same amount that IPAB made in cuts. They can just kind of change where they make the cuts. But that's it. So Congress's hands are basically tied when it comes to superseding IPAB proposals. So let's say, and this is, I want you guys to imagine this, use your imaginations for a bit. Let's say Congress gets some sense knocked into it. Let's just say, hypothetical, right? We're lawyers, we talk in hypotheticals all the time. Let's say a hypothetical that Congress decides, you know, this IPAB, not such a good idea, not such a good idea. What if Congress wants to get rid of IPAB? Then what happens? Well, IPAB is basically unrepealable. That's right. Congress has tied its own hands. Can't really get rid of IPAB. There is a small window in 2017, talking about a couple months in 2017, that Congress can repeal the Independent Payment Advisory Board. Congress has to introduce its repeal legislation between January and February, and it has to be specifically worded. There is actual, in the statute, it tells you exactly how that repeal legislation has to be worded and titled, and Congress has to copy and paste that, introduce it, get it passed by 3/5 supermajority of both houses. Now, it's not just 3/5 of all people who are present, which is typically how we calculate majorities, as long as there's a quorum. This is 3/5 of all elected members. So, present or not, 3/5 of both houses in this couple-month period have to vote to repeal IPAB in 2017. That is the largest super majority requirement in American history. And that's got to happen within a couple months. And then, of course, the president's got to sign it, right? Which I'm sure is going to happen.
Right.
So, and all that has to happen in a few months. If it doesn't, IPAB will never be repealed, according to the statute. But even worse, if IPAB is not repealed in 2017, Congress not only loses its opportunity to repeal it, but it also loses its opportunity to supersede, by that crazy procedure we just talked about, any of IPAB's proposals. So in other words, after 2017, if IPAB still exists, then it's IPAB's way or the highway. That's it. It makes the laws. Congress can't do a thing about it. So, we were reading through the healthcare law, came across IPAB, read that, and thought, you know, that doesn't sound constitutional. Does not sound constitutional. And in fact, it's not. Our Constitution, when the framers drafted it, they were very much aware of how bad consolidated power could be and how that tramples on liberty. So they created a government with divided powers, right? We all learned this in high school, the Federalist Papers, right? We know we have 3 branches of government. They all have very specific powers. The legislature is supposed to make the laws, right? You got your pocket constitutions right there. If you pull it out, you look at Article 1, it says all legislative powers herein granted go to the Congress, right? That's that. So, we have this nifty doctrine, because lawyers love doctrines. It's called the non-delegation doctrine. And that means that since the Constitution says that Congress has to make the laws, then Congress has to make the laws, and it can't give away or delegate its powers to any other body, right? Makes sense, because Congress is supposed to make the laws, and that's how we protect the people. Congress is the branch closest to the people because it's directly responsible to you. You elect your congressmen and senators, and if you don't like them, then theoretically you vote them out, right? So that's why the president doesn't make the laws, and that's why the courts don't make the laws. So the Supreme Court has interpreted the non-delegation doctrine over the years, and it said, well, you know, in an increasingly complex society, I always love when sentences start with in an increasingly complex society, because of course that means that the second part of the sentence is some description of how we're going to take away your liberties. Anyway, in an increasingly complex society, Congress is going to need to give some responsibilities to some unelected boards or something, because, you know, we're going to need to administrate, right? We got to administrate. There's so many people and so many complexities, and never mind that maybe the government shouldn't be involved in all of these complexities. We'll put that aside. Okay, but the Supreme Court said our Constitution does in fact say that the legislature has to make the laws. So if Congress creates these agencies to help it administrate, these agencies will administer the law. They will not create the law. They will help carry out the laws. They can't have discretion. So in other words, Congress will explain what they're supposed to do, and then those agencies just carry it out. And that's that. So, and how do we determine whether or not an agency is just carrying out or administrating the law, or whether or not it is actually making the law? Well, the court came up with this nifty phrase called the intelligible principle. So if Congress has given to this agency an intelligible principle to guide it, something to guide its activities, then theoretically there's no discretion for the agency and it's just carrying out the law. Well, you know, sounds maybe a little dangerous, but sounds kind of reasonable, kind of makes sense, right? If we accept that we have to have administrative agencies. Except for that, the Supreme Court has not found that a law violates the intelligible principle doctrine since the New Deal. Since 1935, there were two Supreme Court cases in 1935, both on the same area of law, is the National Industrial Recovery Act. And this is the law that basically said that the president got to control the entire economy. And the court said, yeah, that goes a little too far. No intelligible principle to guide the president here, so we're going to say probably a delegation problem and unconstitutional. That was the last time that the Supreme Court found any law to violate the non-delegation doctrine. Now, I'm sure sitting out there, you can think of all sorts of things that violate the non-delegation doctrine and that don't have an intelligible principle. And there have been cases that have gone before the Supreme Court. The Supreme Court does not like to admit when it gets something wrong. Those justices don't like to do that. So very rarely, sometimes, but very rarely, do you see a court saying, you know, when we decided that case, I don't know what we were thinking. We were wrong. That case is overturned. And that's that, right? They don't like to say that. What they like to do is distinguish a case. They want a case to go a different way. They distinguish it. They talk about, well, that case, the facts were this way. In this case, the facts are this way, and so we don't really have to follow the law. That's what they do. So all the cases since these 1935 cases, the court has said, yeah, well, you know, but there is some guidance here, and you know, and Congress really has set some sort of boundaries and that sort of thing. And so ever since, laws have gotten away. But even so, we felt that when we looked at IPAB under ObamaCare, it was worse than any agency we had ever seen, including, by the way, the Federal Reserve. I will explain that to you a little bit later. If you know me, you know how much I loathe the Federal Reserve. Just loathe it. And I will, absolutely.
Yeah, absolutely.
That's right. And even I will say IPAB is worse from a constitutional perspective than the Federal Reserve. So that's bad. So we thought, okay, we're going to bring this case, we're going to revive the non-delegation doctrine, we're going to get a court to actually say that that doctrine does exist. And we brought our case, and we made our arguments, and our judge said, No, it's all right. IPAB's okay. It doesn't violate the non-delegation doctrine. There is, in fact, an intelligible principle guiding the Independent Payment Advisory Board. So we said, all right, what's the intelligible principle? Now remember, I told you what guided the Independent Payment Advisory Board. I said that it could do anything related to Medicare, right? Doesn't really sound like much of an intelligible principle. But supporters of IPAB point out, no, look at the law, there are some limits. For example, the law says IPAB cannot ration care. Right? You all probably heard Secretary Sebelius say that. IPAB can't ration care. Never fear, IPAB will not ration care. Okay, fine. So I flipped to the definition section. I said, all right, how do we define ration care? Because that's important, right? And I looked under ours, and nope, ration's not in there. No definition for what it means to ration care. So how do we know if IPAB's rationing care? Well, first, let's think about it. IPAB, one of its many things that it gets to do is it gets to set reimbursement rates to doctors, right? So you use your Medicare to get a surgery, just say, and the government's going to pay, Medicare's going to pay that doctor. IPAB gets to set that rate. What happens if IPAB sets that rate really, really, really low? What if it sets it cost prohibitively low? What if the doctors can't afford or don't want to perform a surgery at that low level? Then no more doctors will be performing that surgery, or they won't be taking Medicare patients. And that care won't be available. Is that rationing care? I don't know. The law doesn't say. Sure sounds like it to me. So IPAB could easily do that. And keep in mind, too, IPAB also is not supposed to cut benefits, and it's not supposed to ask anyone to pay a higher premium. Can't increase premiums, can't cut benefits. What's left but to ration care, right? So whether IPAB rations care in that sneaky way or in a direct way, what would we do? I mean, we don't have a definition, but still, we're reasonable people, right? We can look in a dictionary, see what the word ration means. That's what courts do when there aren't definitions within a law. So what would you typically do if, in fact, an agency is not following its guiding statute? You would say IPAB rations care. You'd go to court. You'd tell the court, IPAB's rationing care. Law says IPAB can't ration care. Please stop IPAB from rationing care, right? That's how it works in the American judicial system, except in ObamaCare, it says IPAB is not subject to judicial review. So when IPAB makes its proposals or writes its laws, you can't challenge them in court. So not only do we not know what it means to ration care, but even if IPAB does ration care, if IPAB blatantly violates its statutory guidance, we can't go and have the court stop it. That's it. So whatever intelligible principles that we may think exist within the law clearly are meaningless because they're unenforceable. So IPAB can do whatever the heck it wants, right? So we will be appealing our lawsuit on those grounds. But IPAB is actually even worse than this. It goes beyond just the non-delegation doctrine. Let's go back up just a little bit to what I was saying about the separation of powers. We have two other branches of government here, right? And they all have specific duties. We've got the legislature that makes the laws. We've already talked about how IPAB takes that power away from the legislature. We have the judiciary that's supposed to review the laws. And we already talked about how IPAB takes the power away from the judiciary because you can't sue over IPAB. Can't challenge it in court. Well, also hurts the executive power because the president, in the Constitution, it says the president can recommend laws to Congress, right? That's a constitutional power of the president. But when IPAB makes its recommendations, the president can't change them at all. Can't touch them. Even though the president appointed those 15 people, or however many people he decides to appoint, so far is 0, he can't do anything about the recommendations, laws, that they make. So what we have is an agency that combines all three powers, the executive, the legislative, and the judicial powers, in one body and is subject to none of the constraints of those. That sounds like what our founders were afraid of when they wrote the Constitution, which is why they separated powers into 3 distinct branches, right? So it doesn't just violate the non-delegation doctrine. IPAB violates separation of powers broadly. It takes all the powers away. Some other fun things about IPAB: it's not subject to administrative review. It doesn't have to go through notice and comment rulemaking. All sorts of other agencies have to go through what we call notice and comment rulemaking, right? Because if these agencies are going to be creating rules or regulations, then the idea is, well, we'll put a check on them by having them propose those to the public, letting the public comment, give its input, before it actually goes ahead and makes them into regulations. IPAB doesn't have to do that. It can if it wants. I'm sure it will. Doesn't have to do that. Also, the people that the president appoints to be on IPAB do not have to be bipartisan. So the president could appoint all Democrats if he wants. Now, there are a whole slew of agencies that require bipartisanship. Not IPAB. It doesn't have to be bipartisan either. And, as I said, it's not subject to judicial review, which, by the way, the Federal Reserve's actions are subject to judicial review. This is why I say that it's even worse than the Fed. Now, people do sue the Fed sometimes. They don't win very often, I'll tell you that. But they do it. Theoretically, it's possible. And not with IPAB. So, violates the separation of powers doctrine. IPAB is a monster. Now, do you think it's a death panel?
Yep, pretty much.
You know, I don't think it's that far-fetched to say that it is, but I'll leave it up to you. So, it sounds pretty depressing. We have, as I said, Judge threw our lawsuit out at the trial level, so we have appealed to the 9th Circuit Court of Appeals. If you know anything about the 9th Circuit, you'll probably know that they're going to agree with us immediately and overturn the district court.
Prop 8.
Yeah, right, yeah. No, you know, it depends, but most likely our case will be going up to the Supreme Court. Yeah?
Who was the judge?
It was Judge Murray Snow.
Harvey Snow.
That's right, yeah. Now, in all fairness to Judge Snow,
Why?
he's probably seen what the presidents have looked like. A lot of times trial judges feel like their hands are tied by higher courts and by presidents, and that they have to rule a certain way because they don't want to get overturned. That's I'm doing my diligence. But anyway, we're going to the Supreme Court. One way or another, this is going to the Supreme Court. Now, what kind of luck will we have at the Supreme Court? This is where I think there is some reason to be optimistic. A couple of reasons to be optimistic. One, our lawsuit has made people aware of IPAB. It was buried in those 2,000 pages. And now we hear people all over the place talking about IPAB, right? I mean, probably can't do, like Jay Leno does his jaywalking. I'm sure if he went up to some college kids in Los Angeles and asked them what's IPAB, I can't even imagine what kind of weird answers we get. Don't think they're going to say, oh yes, that's the 15 unelected, uncomfortable bureaucrats that are going to govern our healthcare industry. I don't think they'll say that. Nevertheless, there are a lot of people that know about IPAB. Also, there is bipartisan opposition to IPAB and a bipartisan effort to repeal it. Democrats and Republicans alike do not like the Independent Payment Advisory Board, so there's some hope there. And on top of it, there is some hope at the Supreme Court, because a couple Supreme Court justices have looked at how our cases have gone since the New Deal. They've looked at how we've treated the non-delegation doctrine. They've looked at how we've treated separation of powers, and they're concerned. And they said, if we get the right case, we're willing to reconsider what we've been doing here, and we're willing to really give some serious review to these laws. And I want to leave you with a quote from Justice Scalia on this very issue. Now, Justice Scalia wrote this in a dissenting opinion 25 years ago. He didn't like the way the court had been treating the separation of powers, and he said, imagine, if you will, what's going to happen if we continue to go down this road. He said, the court's treatment will make it, quote, tempting to create an expert medical commission, mostly MDs, perhaps a few PhDs in moral philosophy, to dispose of such thorny, no-win political issues as the withholding of life support systems in federally funded hospitals.
25 years.
Sounds a lot like IPAB, no? So, we'll see if Justice Scalia, if we can hold him to that when we get to the Supreme Court, but you better believe that we are going to fight all the way to the Supreme Court and at the Supreme Court, and we will continue doing that. We ask you to spread the word. We appreciate your support. We can't do this without your support and without your help, and the Tea Parties have been great. So get the word out, spread the word, go on our website. I have actually brought, where are they? Some complimentary membership cards. If you fill this out and drop it in the mail, or you can return it to me before we leave tonight, that will get you a 1-year complimentary membership to the Goldwater Institute. We will send you emails, we will send you publications in the mail telling you what we're doing with our various cases, including everything we're doing to fight Obamacare. And we'll also let you know when we have events, speakers, dinners, things like that that you can come to. So I ask you to fill that out. I thank you for listening to a lawyer babble on for this amount of time, and I'm happy to take your questions. All right, where do we start? You know, I'm going to pick on the Aloha shirt because that is a very cool shirt. That is a very cool shirt.
He's from Hoboken.
What's that?
He's from Hoboken.
Do you work with the Heritage Foundation? You guys work together?
We, Heritage Foundation is a sister organization, so we do similar work. We haven't really worked much together on the Obamacare issue, but we do sometimes work together, yes.
So if you needed to combine your forces, you could?
Yes, absolutely. Yep. Yes.
A couple of things real quick. You realize that physicians are bringing a lawsuit against this whole thing because
Right.
violation of privacy.
Yep.
Okay, because all of people's records have to be open, okay, for the government to scrutinize. Okay, so they're going to sue on that behalf. The other thing is, if I'm not mistaken, the Congress has the power of the purse. The House has the power of the purse. Can't they just zip it and choke it off?
Very good. Good observation and a good question. I'll start with the first, the privacy issue. I should mention that our lawsuit is not limited to just IPAB. We have a couple other claims too. IPAB is the centerpiece of our lawsuit, so that's why I mentioned that one. We also have our own privacy claim in the lawsuit. And by the way, if any of you are interested in reading our legal briefs or summaries or anything, it's all on the website. Every single thing that's been filed in this case from us or the government is on the website, and you can feel free to go on there and look. But our privacy claim deals with the mandate, or I'm sorry, the tax. And specifically, we say, well, look, if we are forced to purchase health insurance or penalized if we don't purchase health insurance, then there are some privacy rights that we're having to give up because of that. Because if you purchase health insurance, of course, the insurance company is going to ask you all these personal questions, right? Whether or not they can deny people based on pre-existing condition or any of that, the health insurance company's got to know about you in order to make its risk assessments and know how much money it's going to be paying out and things like that. Now, of course, in a free market, that's perfectly fine. It's a voluntary transaction. No problem if they want to collect information from you if you're voluntarily giving it. But if the government is saying, you have to purchase a private product from a private health insurance company or we will fine you, then you're basically being told you have to give up your personal information to a private company or we will fine you, right? That is a violation of privacy rights. On top of which, as we know, courts have said, hey, if you give your personal information to a third party, it's fair game for the federal government to go ahead and ask for that personal information. We know Google has that trouble all the time. And so it's possible that